Hello and welcome, Disability Law Show. Good to have you back again this week. I am John Scholes, and beside me, through the miracle of split screen and television, would be Sivan Tumarkin, the co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed disability law firm in the land. That is something actually worth Googling anytime you want to do that. Practicing out of Ontario and BC and Alberta as well. You want to reach Sivan anytime when the show's not happening. 1-855-821-5900, help at disabilityrights.ca. And I'm going to give you another website, mydisabilityquestions.com. We will refer to that probably more than once during this half hour. You can go there anytime. Ask your questions about LTD, whether it's for yourself, a family member, or a colleague. It's totally anonymous, takes a few minutes, a couple minutes actually. And there's also a searchable database there too. So that means if you type your question in, you can see if a question similar, if not exactly like yours, has been asked and answered in the past. If not, leave it there. Sivan and his team will get to it. We got a lot of stuff to get through today on the show, my brother, including 3 facts about insurance adjusters that can help your LTD claim. That is a little bit in the future. But we always start off with something that's been going on your desk. A little bit of a week that was. How are you, pal?
I'm great, John. It's just been a very busy week. And again, I say this every single week, but the reality is it's been very busy. And again, because we practice in all 3 provinces, in Ontario, in BC, and Alberta, we see claims from all 3 provinces, all over these provinces. And what we do here, John, each and every week is we educate the public about their legal rights when it comes to long-term disability claims and how to deal with their insurance companies. And so I'm talking now directly to people out there. You do have rights. You have to stand up for your rights. You have to get the right information. You have to be empowered, but you have rights. Don't let insurance companies do whatever they do, which is deny claims, John, cut people off benefits prematurely, and ask them to do things that they're not allowed to ask them to do under these policies. Let me tell you about a call I had this week. I spoke with a gentleman out of Calgary, and he's 52 years old. He's an account executive. He suffers from Parkinson's disease. He has a few young kids at home. And in addition to Parkinson's, as you can imagine, a very, very tough disease, he also has depression as a result. So, of course, he has treating doctors, and everybody has said that he's disabled from working. And he has been on LTD. He was approved by his insurance company for about a year or so. After about a year of being on LTD, he then thought, with consultation of his doctors, maybe I can try and go back to work. I can do something. Which is great, fantastic. I mean, we always tell people, if you can go back to work or you think you're ready, talk with your doctors. If you have the okay, try and go back. And so he did that. Insurance company was aware of it. That's all great. And so he tries to go back, and it's a complete disaster. At the beginning, it was okay. And then, of course, as he continued the work, about 3 weeks later, he realized, no, this is just not doable. I'm simply not well enough to do my job. I have to go back on LTD. And his doctors all agreed. And so he spoke with the insurance company adjuster. And of course, what the insurance company adjuster says, no, we don't think you gave it a good go. We disagree with your doctors. We ran this by one of our internal doctors or in-house doctors or consultants, whoever it is that reviewed this and said, no, we think that you should continue trying to work. And remember, this guy, out of his own volition, out of his own sort of strength and willingness to try and go back to work, attempted this gradual return to work. He wasn't forced to do it by the insurer. He tried to do it because he doesn't want to be on LTD. It's exactly the kind of person you want, out there, not a person who's just going to collect LTD all his life. It's a person who, if he feels he's ready to go back, will take the steps necessary to try and go back. And he does that, and what happens? He gets penalized by the insurance company, who then say to him, no, we're not going to put you back on LTD. Now, here's the thing. Every LTD policy out there that I have seen contains what's called a recurrence clause. Yep. It's a provision in LTD policies that acts as a safety net in the event that you try to go back to work and are unsuccessful within a certain period of time. It varies. That period of time varies. Usually it's about 6 months. So if within that period of time you try to go back to work and you are not able to, and you have to go back on LTD, again, with the support of your doctors, your insurance company should put you back on LTD without waiting any time. In other words, without any time where you're not getting paid, without the elimination period, which is that period of time at the beginning of an LTD claim where you don't get paid. So this insurance company says no. And what does this gentleman do? Does the right thing. He appeals that denial. And of course, 2 months later, he gets a response from the insurance company again saying, no, Our consultant, doctor, whoever it is that looked at his record, never even met him, disagrees with all his doctors and says, no, we think that he should be back at work. I explained to this gentleman, this is a very easy claim to resolve. It's not going to be tough. They're banking on him walking away from this claim. And again, this man has Parkinson's, John. So really important to understand, if you try to go back to work and you're not successful, you should be able to trigger the recurrence clause under your LTD policy, which will allow you to start getting LTD again. And if you run into any difficulties, that's when you get in touch with us. You call us. You don't appeal. You call us and we will help.
I find this interesting as opposed to, say he was off for, he got in a car accident or he's, a spine problem or a broken leg or something. Either way, then they can say, it's about time you got back to work. Does this company realize that Parkinson's is a progressive disease? Chances are he's not going to get better. Chances are he's going to get worse over time. And how's the insurance company going to attack that approach? You're
right, John. You're absolutely right. Which is, what I say often is that insurance companies and adjusters, many adjusters, just work like automatons. They don't have medical expertise. They don't even have legal expertise, many of them. They simply do what they're instructed to do. Whatever the manual says, they follow that manual. And really, the insurance manual, sort of from an abstract 20,000 feet standpoint, is deny, deny, deny. We see all these Hollywood movies, those John Grisham books that we read about insurance companies acting in such a horrible way towards individuals where they've been collecting premiums for years and years and years. And yet, when the time comes and the person needs help, they deny or they cut off your benefits. So that's what they do. That's simply what they do. So you're asking me, how is it that they get that? Listen, John, I've seen the same situation occur with somebody who's battling 4th stage cancer. So, people who are in terrible, terrible accidents and have terrible illnesses. Insurance companies are in there only for themselves. No matter what you see on TV, on these commercials, the radio commercials about insurance companies being there for you and helping you. And by the way, it's not just disability insurance. It's house insurance. It's car insurance. Sure, sometimes you'll get good adjusters, empathetic adjusters. Sometimes you'll get people who are going to try and help you. But for the most part, insurance companies are there as a business to make money. And one of the ways to make money is to deny your claim. It's up to you to stand up for your rights. And that's what we're here for, to educate you about your rights and to help you if you find yourself in that situation, because that's what we do. We resolve these kinds of cases and we push back against insurance companies.
With a disease, again, like Parkinson's, in this perfect example you threw out there, Sivan, is it likely that eventually, because of the nature of the disease and it's going to keep getting worse and worse, will they eventually come to the table and offer him some sort of buyout or final lump sum payment to get him off their books? We don't know how old he is, unless you mentioned how old he was. I don't think you did. But is that a possibility? And should he even entertain that thought?
John, this guy is early 50s. So we're talking about a fairly good amount of time that he's going to be paid LTD if he cannot go back to his, to his job or to any job beyond the 2-year mark of LTD. We'll talk about that later. Is the insurance company going to come to the table? Oh, yeah, they'll come to the table because we're going to force them to the table. So insurance companies operate, they only understand one thing, which is force. If you don't apply pressure on them, they will not pay. It's a jungle for them. They are the line, or at least they want you to think that they're the line. What you need to understand, and every listeners and viewer need to understand, is that the law is there to protect you. It's not perfect by any means, but insurance companies are not above the law. And what I mean by that is, when we start that legal process and we go to the insurance company, and they know us, by the way, across the country, we've dealt with insurers across Canada. We know the insurers, we know their lawyers, they know us. And they understand that if we get into the picture, we're going all the way. And the last thing an insurance company wants is to have us on the other side when a judge has to decide the case, right? Not them, the judge, which is why I'm saying that in a case like this with Parkinson's, with cancer, but not even those, with mental illness, with physical impairments that are longstanding, we can bring about a resolution by knowing where to push the insurance company and what pressures we can exert on them. Because at the end of the day, they cannot simply not pay when the contract of insurance stipulates that they must.
Our sister show, or brother show, Employment Law Show, you'll see here as well sometimes with Lior hosting that for the most part. And there's an interesting website similar to your mydisabilityquestions.com that is tailored to your audience and your clients. The Pocket Employment Lawyer website, pocketemploymentlawyer.ca, is also engineered for that particular angle, the other half of what you do at the firm. But there is a nice little robust section on disability law at the Pocket Employment Lawyer website and the app you can use anywhere. Explain that a little bit.
Yeah, the Pocket Employment Lawyer is an interesting free website that we had created a few years back. And you're right, John, it deals with employment matters. However, there's a lot of people who contact our firm who have issues not just with their employment, with their employers letting them go or treating them wrong, but also people who are having issues with their disability insurers at the same time that they're having issues with their employers, or sometimes not at the same time. Sometimes somebody goes off on leave, think that everything is okay, then they encounter problems with their insurance company, and at the same time, their employer now says, by the way, we're letting you go. So the point is, if you go to that website, let's say you don't want to call us, you don't want to email us for whatever reason, go to that website, the Pocket Employment Lawyer, and you will see that there is a section there that deals specifically with long-term disability. Input a few pieces of information just so that the website understands what you're asking, and it will custom tailor a response for you. And at that point, if you want to get more information, you want to speak to one of us for free, by all means, press submit. You don't want that? That's fine. Close the browser. We will not know that you were there. But Pocket Employment Lawyer is this unbelievable website. It's been accessed thousands of times across the country, John, by people who simply want to get information, correct information, accurate information within seconds, and who understand that they can't rely on Dr. Google for this kind of vital information of their case.
You also have the option, including pocketemploymentlawyer.ca for good old-fashioned email. How about that? help@disabilityrights.ca. Want to get to the first one for the show today. This one from Miranda. Miranda says, I've been off work from my cleaning job since last summer due to severe back and knee pain, which I'm awaiting surgery for. While I was approved for CPPD, the insurance company denied my LTD because they said I'm not, quote unquote, totally disabled and could do another job. Given the amount of pain I'm experiencing, I have no idea what other work they think I can do now.
This is quite interesting, John, because we do have people who apply not just for LTD, but CPP disability. In fact, we tell people who are disabled, who have disabilities that are severe and prolonged, that's the criteria, main criteria for CPP disability approval, we tell them to apply for CPP disability. Now, if you get approved for that, you have to understand the federal government has deemed you disabled from working. For the LTD insurer to then come around and say, we don't believe that you're disabled from working when the government has, that's a bad look. And just imagine if a judge is, again, looking at this case. A judge is going to have something to say about the fact that the government has deemed you disabled. So, cases like that, typically we can resolve very quickly, sometimes out of court, sometimes, before a legal claim is even issued. The point is, you do not back off. That's my message for people out there. You do not back off when the insurance company cuts you off benefits or denies your claim. If you back off, you're doing exactly what the insurance company wants you to do, which is give up on money that they owe you. And I want to underline that they owe you. Right? When the insurance company comes to the table, John, and they put money on the table, they open up their checkbooks and they're willing to pay you thousands of dollars, sometimes tens, if not hundreds of thousands of dollars, maybe even more. It's not because they're a charity, it's because they understand they have no choice. So in this case of this lady, I can tell you right now, without even knowing a lot about her case, if she was approved for CPP disability and the insurance company takes the opposite view, as soon as this gets into the hands of a defense lawyer for this insurance company, we're going to be talking Turkey. There's going to be a resolution. This insurance company will not want to take the chance of facing us in court, and it's never going to get to court. By the way, most of these cases never, ever go to court. They just don't. This is not American TV. These cases resolve way, way before that. We typically resolve LTD cases within weeks, maybe months after we get involved. Some cases go on for a bit longer, but it depends on the facts. But the reality is that the insurance company is well aware of your medical documentation. They're well aware of your case. As soon as we get involved and then they get their defense lawyers there, we speak the same language. And at that point, we can get to the table and actually do what needs to be done, which is get money in your pocket.
Coming up, we're going to take a short break. 3 facts about adjusters that can help your case. We'll get to that, but we'll take a short break first. As mentioned, the phone number anytime to reach out, 1-855-821-5900. And email help@disabilityrights.ca. We'll continue. More Disability Law Show is coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Disability Law Show. Thank you so much for hanging in during that little break. Coming up here, Sivan, the topic for today, three facts about insurance adjusters that can help your LTD claim. 3 things you need to know. The first one is this. Insurance adjusters sometimes decide to deny LTD claims without reading all of your medical documentation. Lazy. What is that all about?
John, let me say this. So when we prepared the material for the show and we talked about this, I really did debate the word sometimes. And I only say that because I don't have statistics. But anecdotally, speaking to my group, my own experience over the years, I don't know how many times I can tell you that when I've delved into a case, really sunk my teeth into it when there was a denial which was clearly inappropriate, and I've looked then at the records, at the notes, the actual notes that the adjuster had made, the adjuster that was adjudicating the file. Because remember, it's not the same adjuster that deals with the claim when we get involved. When the claim goes to a legal process, the file shifts within the insurance company to a different adjuster that deals with these kinds of claims. So it's not the original adjuster. And when I look at some of these records from the original adjusters, you can plainly and clearly see that these adjusters have often not done what they were supposed to. They've either not reviewed medical documents from a specialist or from a family doctor or a physiotherapist, psychologist, whatever that is. And you can see that because when I question them under oath, they've admitted that in the past. I even had a situation with one of my lawyers telling me that he had one time an adjuster under oath, he was questioning her and asked her, did you review all the medical documentation that you had at the time before you made your decision to cut off this person off benefits? And she says, yes. And then he pointed her to the family doctor's records, which were illegible. And he said, did you get those transcribed? Did you? And she said, no. Were you able to read those? And she says, no. She says, so you had these in your possession from the family doctor, the primary care physician, and yet you were unable to read these records. You did not read them. And despite that, you decided to cut off this person off benefits. And she said, yes. I mean, the lawyer working with me then looked at the defense lawyer from the insurance company and they exchanged stares. And I can tell you the case resolved very quickly after. So my point is that insurance company adjusters oftentimes do not look as closely as they should at all the medical documentation and other documentation, frankly, because it's not just medical, that they have in their possession before they make a decision. More of a reason for why you should stand up for your rights and not accept a denial if you are in fact disabled, if your doctors say you're disabled, and if the insurance company takes issue with that. Because at that point, we can help you.
Fact number 2 is this, Sivan. Adjusters may make decisions based on incorrect information provided by their consultants. I know you love that word.
I do, because when you say consultant, oftentimes insurance companies retain or hire a third party. Sometimes they have those on staff. Sometimes they simply hire them. Sometimes they hire doctors to review your file. Sometimes they hire consultants. By consultants, I mean non-MDs. Now, look, there are many people out there who are not doctors who are very qualified to provide certain opinions about certain things. But oftentimes, these doctors, these consultants, maybe they have access to your file, but is it your complete file? And does your file say everything there is to say about you? I mean, don't forget, your doctors have known you for months, if not years. Your doctors have interacted with you. They know you intimately, as opposed to a quote-unquote consultant who potentially doesn't know you, second of all, simply treats you as a file, as just a stack of papers, and you're not. You're a human being. And so when adjusters make decisions on the basis of what their consultants or doctors say to them, and those are in contradiction to what your doctors, your treating providers are saying, there is a problem there. Look, any day of the week, if I am a judge and I am posed treating doctors on one side, a consultant who's only seen you once or hasn't even seen you has only looked at your records and you weigh their recommendations, their diagnoses, their prognosis, if I'm a judge, I'm going to go with whoever's treating you. I'm going to assume they know you better. I'm going to take them at their word more than I would a consultant who's a hired gun for the insurance company. And you need to understand that. That is the Achilles heel for many of these denials. And we can go after those insurance companies, and we often do, and we beat them at their own game because at the end of the day, they come to the table and they open up their checkbooks.
We were talking about 3 facts about adjusters that can help and change your LTD claim for that matter. Number 3 is this one, Sivan. You are well within your rights to report your adjuster and request a new one if you feel like you've been mistreated by the first one.
100%. I've seen many cases, heard of many cases as well, where individuals who are already suffering from debilitating illnesses, some of them are mental illnesses, mental health illnesses. It's even worse in those situations where the adjuster is being very rude, bullying, harassing, using language, inappropriate language. There's no reason for that. If your adjuster is not acting in a way that's respectful to you, is not acting reasonably, you have the right to complain to a higher up in that company, in the insurance company. Mm-hmm. And they should be providing you with a different adjuster. And if they don't, you have a right to then take action. What that action is depends on each case, right? If it comes to the point where whatever the adjuster is doing is in fact exacerbating your disability, maybe it's making you more depressed and anxious, you may even have a claim against the insurance company for this. Remember that insurance companies owe you a fiduciary duty. That's a sacred duty. That's legal talk. But essentially what you take away from that is that they owe you a lot. As an insured person and them being an insurance company, there's a power imbalance. They owe you to treat you in a respectful manner and to look out for your interests. They've undertaken to do that contractually through the policy, through collection of premiums. And so if you have an adjuster that's very difficult or an adjuster is being unfair, you have every right to ask for a replacement and to at least put the insurance company on notice that if you were to consult a lawyer, you're going to take this into account if you end up starting a claim.
I did at the beginning of the show, Sivan, and as you know, if you're watching, a website called mydisabilityquestions.com. That's free. It's anonymous. It's another place for you to ask questions and get Sivan's team to have a look at them and answer them and give you some satisfaction about your LTD questions. Again, mydisabilityquestions.com. We're going to go there, but we got to take a break first. In the meantime, here's the number to reach out anytime, 1-855-821-5900, help@disabilityrights.ca for email as well. And we'll continue. More Disability Law Show. Hang on. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, we are back. Welcome. A few minutes to go on the Disability Law Show. You want to reach out when the show is done. Any other time for that matter, the phone number is 1-855-821-5900, help@disabilityrights.ca. And another place to ask your questions, absolutely free and anonymous. Get some satisfaction. I just mentioned it. We're going to get to it right now. mydisabilityquestions.com. By the way, searchable database, so your question may have been asked and answered quite thoroughly in the past. So you can do that ahead of time and save some time. So, Sivan, we got Dominic right again on mydisabilityquestions.com. Says, I was told to attend a medical assessment after being on LTD for several years because of significant mental health issues. The doctor confirmed that I'm still not able to work, but that didn't matter to the insurance company. I've been told that my benefits will end soon and I'll be put on a return to work plan. This news has made me feel worse than I did before. How should I proceed?
John, every once in a while we talk about cases that potentially can attract extra contractual damages against insurance companies. What I mean by that, for anybody who hasn't heard us before talk about it, is extra damages that you're asking a court to award against an insurance company to punish them for egregious conduct. This is one of those cases where I would be asking for this. So just for context, this gentleman here has been suffering from mental health issues. Not only does he have the support of his doctors to be off work, but the insurance company has asked him, demanded of him to attend an assessment with one of their own doctors. And when we're talking about the insurance company's doctors, John, the terminology for that is independent medical examinations, IME. And these are anything but independent because the insurance company selects a doctor, they pay the doctor, they instruct the doctor knows what the insurance company wants from them. At the end of the day, this doctor works for the insurance company. And so in typical situations, what we see is these paid hired guns, let's call them that. We see them crank out an opinion that is favorable to the insurance company, typically saying the person is not disabled or not disabled sufficiently so they can't work, recommending the person does try to go back to work, etc. That didn't happen here. In this case, the insurance company's doctor actually said that this person is unable to work, that he continues to be disabled. So that doctor is essentially in line with the opinions of the treating doctors. Despite that, the insurance company has now told him that he must start a return to work program, which of course has created a significant issue now for him from a mental health standpoint. This is a case where, if the insurance company gets out of this by not paying anything in addition to what they already owe, I'll be surprised. Certainly that would not happen with us. We would press them to the wall. We would not give them an inch on this. And I can tell you, John, from having spoken and done many of these cases and spoken with defense lawyers, no defense lawyer will want to have this case on their table. No defense lawyer will want to have to argue a case like this because it's a losing battle. This is a situation where, frankly, to be blunt, the adjuster is a moron. And I say he's a moron because he's just cost his insurance company, his overlords, a lot of money that otherwise they would not have had to pay. You don't do that. You simply don't do that. You have to be fair. Remember, we talked about the last segment, fiduciary obligations. You must be reasonable in how you adjudicate these claims. You hired your own doctor who told you that this person is disabled, and despite that, you're ignoring what your own doctor is saying. You're ignoring what the treating doctors are saying. You're ignoring everyone. And in your wisdom, you're saying this person is not disabled enough from not trying to go back to work. It's complete nonsense. This is a prime case, John, where we would sink our teeth into and drive everything we have into the insurance company to squeeze everything they have for our clients.
If we go back to the beginning of this story, though, does Dominic have to go for this assessment? Is it mandatory, or can he say, I'm not interested?
You do. And one website we haven't mentioned yet, it's ltdfaq.ca. ltdfaq.ca. It contains memos that deal with this as well, where it answers questions like, what do you do in an IME? Do you have to go? How do you act in this examination? What do you do after, etc.? But yes, you do have to go. But here's the thing. If the insurance company wants you to be seen by one of their doctors, they are trying to figure out how to cut off your benefits. So you should be contacting us immediately so we can tell you what to do.
So he has to go this, and if it turns out in a different scenario he needs treatment, they're not the overlord to his treatment. He can go where he wants to for treatment, yes? That's the difference.
You got it. You can get treatments wherever you want. As long as you're getting reasonable treatments, you can't simply say, I'm not getting any treatments, there's no one in my area, and that's that. If the insurance company can provide an option for you. So no, but if they tell you, you want to go to this clinic for psychological counseling,
right,
and they want you to go there, you can choose whoever you want to go to. But if it's an assessment, yes, you must go. Again, with some caveats, which is why I'm telling you, contact us if you have this kind of an issue. We'll talk to you for free.
Good way to wrap it up for today. Now you want to reach out to Sivan if it's piqued your interest anymore. Here's a bunch of different ways. Phone number first, 1-855-821-5900. help@disabilityrights.ca. That's the email address we use. And right there, mydisabilityquestions.com. Free and anonymous. Reach out and use it and get some answers. Thank you so much, and we'll catch you next time on the Disability Law Show.